On my lord 11/6/2025, my lord, a report has been submitted by the registry on the registry, my lord. 11, or we receive on 11/6, my lord, probably some latest, my lord. So far is, my lord, list of criminal case pending is
B flag B. Date set language translation. Huh? This is where flag B. Date set.
the latest.
A flag A also. Flag A. And the report is at R5. It will be.
26/5. There is for office note, there is a
26/5.
26/5. 26. So far is, my lord, first page, annex page A, my lord. These are the 6 cases, my lord, pending before this High Court and principal seat, my lord, and status has been given. And in the page, second page, my lord, there are 12 cases, my lord, mentioned about that, my lord, that is pending before already. Out of those, my lord, serial number 5 and 8 are disposed of. And I made an inquiry, serial number 2 is also disposed of. Serial number 2, page, my lord, that is second page, my lord.
B, flag B.
So serial number 5 is, and my lord, I made an inquiry, the serial number 2 is also disposed of, because it is a report, my lord, prepared on probably no, it is there is no mention, and up to what date, this is not mentioned. Just disposed of very recently, my lord, and that is on 26/5. Serial number 2, my lord, criminal appeal 1/24/2025. That is Akhil Gogoi's case, my lord, that is disposed of. Yes, my lord, in the other part, my lord, your lordship kindly see in respect of other, that is my status as on 17/3/2020. I have seen, my lord, state as on 17/3/2025. And that is, my lord, page, your lordship kindly see page number. There is no pagination, my lord. There is no pagination, my lord. Yes, my lord. Regarding, my lord, in earlier order, my lord, your lordship mentioned about 10 cases. Those cases, my lord, the report as on 17/3, my lord.
Good for us.
It appears to the report.
It will no.
Yes. 26.
Oh, you key him. Huh?
Yeah.
Oh, see? Some report দিব বন্ধ হয়ে যাবে এটা রিপোর্ট আছে না এই তো 17 ওয়ার কারণটা আছে অর্ডার ওয়াজ ফাস্ট অন
No, that is not.
It is because your lordships passed the last order on 11th of March.
Of pregnancy of cases on
As on, it is mentioned here in the report of the Registrar General, my lord, 11th of March 2025, it's mentioned there, my lord. I'm sorry, not 11, 17th March. The Lordship's order is on 11th March. Pursuant to that, this report was submitted as on 17th March 2025. My lord.
73. But
It is mentioned on top of this. My lord.
It's one of the High Court. But High Court is clear, this is-
It is earlier, I think.
Next date.
Court has submitted on 11/6.
It is also key.
Vishnu. And our order is on 11/3. So 11/6 only we can presume to do this 11/6 not at our Kumar Nagar. Office note was put on 11/6/2020.
In respect of our principal shipment up to my lord to 16/5, up to me, my lord. Status is up to me. In case of, because the lordship and last posting date is mentioned here. That 12 cases. This is, data is, which date? Some light in that. Report of 26, 26. Up to High Court, up to me.
Up to May, Lordship.
No, that is in respect of principal.
Principal said.
If I should get- Trial court.
Latest date is 19/5. So they are aware of it when they have paper report. So maybe before 19 May also.
19,
So what the date? This one is the next date, 19th, nothing in here. Hey, for me, so this one.
Lordship, I have to go to the file from the section to get the date, Lordship.
Nothing.
Yes. Otherwise, my lord, here Lordship will find the office note which the Registrar Judicial has prepared. That is on 26th of May 2025. Possibly this is, they are referring to this date. 26th of May 2025. 26th of May. Order level. Which is order. First page to 20 years. That is totally one. Hold on. ठीक है ठीक है हाँ ठीक है ये follow the same it is 17 March order to the board ऐसे ऊपर ऊपर 4th of August. Lordship is speaking on 4th of August.
Yeah, vacation in between. So.
Yeah.
For order, I think.
In persons to the order dated Lordship 11/3/2025 Lordship, the state of Assam has already filed their affidavit Lordship regarding toilet facility Lordship. They have prepared a roadmap Lordship. Lordship, perhaps Lordship some time may be given to going on.
29/4/2026.
You don't need the waiting. Important.
Lordships, I have a copy of this. If I may just submit two things for your Lordship's consideration. Lordship will kindly take up paragraph 5, page 1550. They are talking about the budget which has been allocated for the construction and of an upgradation of toilets of the judiciary, which is perfectly all right. 29 for government work. And the other one is paragraph 7, your Lordship. That is the most important paragraph where they're talking about the roadmap. Now, while talking about the roadmap, your Lordship, they are focusing a lot on the construction and the upgradation part. What is lacking is the fact that we require maintenance. Subsequent maintenance is what is most important, your Lordships. I draw your Lordship's attention to the judicial building of the family courts at Guwahati, which was recently constructed. The building is fantastic, absolutely. And the toilets which were constructed were very well constructed. But unfortunately, if your Lordships go and pay a visit, the problem arises when there is no maintenance. So that is the only concern which I would like to point out to your Lordships. And there's a huge roadmap. The roadmap takes about 6 or 7 steps, which is totally understandable. I guess perhaps that is how it will have to function. That initially PWD will make a proposal, then they will send it for approval to the district level of the concerned district. Thereafter, it will come to the High Court. Then after the High Court's approval, it will then go back to the judicial department. Once they approve, it is thereafter that the PWD will start with the construction or the renovation. So this is the roadmap which they have given in paragraph 7 of the affidavit, your Lordship. This is where the legal remittance of, Lordships. That one letter which my learned friend has just handed over to me, but this is prior to your Lordship's order. So I don't think this is on 23rd of December 2024, where they have informed the district judges to talk to the PWD authorities and get. Lordships, I would not have the means to collect the data from the other districts or whatever.
Explain.
Protections. Whatever yours.
Lordships, and to that extent, yes, certainly. Only concern is the maintenance part. That's all. That is nothing else. Yes, I can do that. Not a problem.
Yes, Willow. Yes.
Not required to put in every.
Yes, Willow. Inputs, Willow. Yes. Yes, Willow.
Nagaland.
Last order. Yes.
Yes. Can you hear us?
I think microphone is.
Yes.
Yes, yes, yes.
Can you hear us?
Am I audible, my lord?
Here. You may be far away, but your voice is being heard.
We are not able to hear your lordship also. But
Here now.
increase the volume. Which is on?
Can you hear us now?
My lord, I can hear.
Yes.
Sorry.
Yes, what do you have to say, Mr. Balgopal?
My lord, we had received that additional amount which we had mentioned to your lordships last time,
Yes.
about
You
80
have
crores.
received. You have
80
received.
Yes. So we
Oh,
have received that amount, which
okay.
is
You have received it from whom?
we have received it from the government itself. Union, the money has come.
Oh.
Pursuant to your lordship's kind intervention in keeping the matter alive, and the
Mhm.
persuasion we made in meeting the law minister, etc. And the
Mm.
concerned communication is already on record before your lordships. Last time we had placed it on record. So now
Right.
things are taking a very positive step. Though the finances further may be required for the entire expansion, but as far
Mm.
as things are going on, this is
Mm.
a very reasonable approach, and we are very grateful for the kind intervention.
No,
Otherwise, we would have left
that's
very
very,
behind.
it's very pleasing to learn
Yeah,
that.
the,
But now that you have the 80 crores,
my lord,
the next question will be, what is the date of inauguration of the building?
that we will try and get it at the
Huh?
earliest, and we will definitely bring your lordship wherever
After
you
that,
want.
the government of Nagaland perhaps cannot have any excuse
Yeah, that's right. That's right.
to
That's right.
defer it any further.
We
80
will.
crores is a substantial
Yeah,
amount of
in
money.
fact, the complete budget they have given is much higher, but this is
Yeah.
the amount they have given, and we have said that what are the paces as per the contract, the work will be done, and I think it will be substantial work which will be done. So
No,
I
that's
think
fine. We don't intend to, and we are not required to go that deep into the matter.
that's right. That's right.
All we wanted to know is when are we going to
I,
inaugurate this
I,
building and put it to use?
I think we are seeing the sunlight after the matter came before this honorable court.
Yes,
So
yes.
I think I don't know whether your lordship would be here or wherever your lordship may be in, but your lordship will definitely come whenever we are going to
No,
inaugurate
no.
it. The great
We can
distinction.
observe that this is a very good sign. The government of India has shown the requisite sensitivity,
Yeah,
and for an institution such as judiciary, so it's a very welcome move.
right.
But the
In
question is
fact,
now the ball is in your court.
in fact, this is not a grant. This is a loan.
That's all right.
That's all right. So in the form of
Ultimately, it is your
yes,
responsibility.
it's our responsibility.
So,
So how we do it, and unlike in the state of Manipur, where they got it on different terms, we are not getting it that way. So we are inching towards this, so that we have to even satisfy from wherever we get the money. So your lordship may only state to this extent that this amount, the letter has been placed on record. I think my learned additional ages are there. They may
yes, where is the
forward the
letter?
letter again, please. Those details are there.
So, Mr. Balgopal, will it be an extravagant thought to expect a timeline from the state of Nagaland as to how the
My
construction
lord,
will be taken forward?
keeping that in mind, instead of
Yes,
my making a statement which may not
right,
be very accurate, it
right,
won't be
right,
fair on my part.
right,
But I
right.
will take the responsibility of checking up the details, and in
Okay.
the next hearing, I will be able to make a clear submission. I don't want them to say that I
No,
said this or
that's fair enough.
so. I
But
will.
then why don't some responsible officer file a short affidavit
We
on
will
this,
do it. That will be the perfect thing. We
right?
will do. We will do that.
Right.
We will do.
And
I'm very grateful.
in that affidavit, three things are to be indicated.
Very
First, how this fund is being
utilized.
utilized to expeditiously complete the building.
Correct.
Project a tentative date of inauguration of the building.
keep,
That projection
keep
has
that.
to come from the state. That has
May
to come.
not, may not mention it in the affidavit, but I will take that. It's, I am trying to work out the things in the maximum. I've been assuring this honorable
No,
court
no,
that
we understand. You are doing your level best. We understand. But
may not put the date portion, my lord. Kindly don't do that.
no, but a timeline has to be
We'll
given.
say we will do it expeditiously, and we mean it when we say expeditiously.
Because the other governments, they have done it.
The-
The
we-
government of Arunachal has given a timeline that we are going to
we-
hand over.
So maybe in the next hearing, I may be able to say that also. Let me have a clear discussion with everybody.
No,
Then
let-
I'll place the facts for your lordship.
Let there be a
Kindly do
roadmap. Let there be a roadmap. The timeline will automatically come into it, my lord.
Hmm.
You see, we can do things in many ways, but there are many problems. So we are just trying to iron out the things in such a way we complete the project expeditiously, and we are also to repay
But we
whatever.
will issue a direction today that not a penny of this fund will be diverted for any other purpose other
That's
than
it.
construction of court building.
That's definitely
Cannot be.
no difficulty.
Yes.
No difficulty. It's meant for that. In fact,
Yes.
it is meant for that. That is why we have given the letter. It cannot
Correct.
be used for any purpose whatsoever. We become accountable. In
Correct.
fact, there's no need to. If your lordship wants to mention, that's a different thing. But that is understood. And if anybody does it contrary to that, consequences are there. So
That's right.
nobody will be foolish enough to go in for that. That
That's
can
right.
be rest assured.
Yes. Mr. Dev Chaudhary, would you like to say anything? Right. Right. Anybody else from the other states? Arunachal,
Arunachal.
30th June, is it? You are handing over the building on by 30th June. We can record it.
No, sir, it's in the core committee meeting report.
Ah.
There it is mentioned as June this month.
Sorry, this month.
Lordship.
Okay. Let us see the court committee. Let us see the report. And what about Mizoram? Anything? Anybody?
No,
There's nothing, no issue. All right, you take down heard Mr. H.K. Das and Miss R.S. Chaudhary, learned amicus curiae, were present before this court today. Mr. D. Majumdar, learned senior additional AG Assam, assisted by Mr. E. Nath, learned senior government advocate, Miss P. Bhattacharjee, learned additional AG for the state of Mizoram, Miss T. Ho, learned additional AG for the state of Nagaland, Mr. P. Chandran, learned senior government advocate for the state of Arunachal Pradesh, and Mr. R.K.D. Chaudhary, learned DSGI, along with Mr. N. Barua, learned register administration, and Mr. T. Kaishap, joint register, bracket PNMP, bracket close, are present. Full stop. It has been brought to our notice that in response to the order dated 11/3/2025 passed by this court, the state of Assam has filed an affidavit on 9/4/2025 inter alia laying down a roadmap by indicating the timeline and availability of funds for implementation of the model design of laboratories across the judicial institutions in the state of Assam. Mr. Das and Ms. Chaudhary have both prayed for some time to examine the report in detail, affidavit in details, and thereafter furnish their respective inputs. Full stop. Mr. Majumdar has no objection to the prayer made by the learned amicus curiae. Therefore, the prayer stands allowed. Full stop. Insofar as the state of Nagaland, issues pertaining to the state of Nagaland is concerned, Mr. Balgopal, learned Advocate General of State of Nagaland, has addressed this court through RVC and has appraised us that pursuant to the intervention of this court, the Government of India through the Ministry of Law and Justice. Is it Ministry of Law and Justice or Finance?
We have got it from the my lord may only mention the communications.
Achha.
Little confusion in the hearing for
Submits
me.
that a
As for
communication
the communications, I have placed on record. 80
Has
crores
been-
has been received by
has
our
been
department.
has been received from the budget and from the finance department, bracket budget and monitoring cell, bracket close, government of Nagaland, which indicates that an amount of rupees 80 crores has been received from the central grant for the purpose of construction of new High Court complex at Kohima, including the main building and the annexes, so as to complete the project expeditiously. And after receipt of the funds, all steps are now being taken to complete the project in a time-bound manner. Full stop. On a specific query made by this court, the learned Advocate General Nagaland has submitted that on or before the next date fixed, the Government of Nagaland will file a short affidavit indicating the manner in which the fund so received is being or is sought to be utilized for the purpose of completion of the construction expeditiously. Full stop. On the request of Mr. Balgopal, time for filing affidavit as prayed for is hereby granted. We, however, make it clear that the fund received from the central government as special assistance for completion of the construction work of the new High Court complex, along with ancillary buildings in Kohima, shall not be diverted for any other purpose whatsoever. Full stop. Insofar as the state of Arunachal Pradesh is concerned, Mr. Chandran has appraised this court that as per the resolution adopted in the meeting of the core committee, the new High Court complex will be handed over to the new High Court complex being constructed at Itanagar. Is it Itanagar or Naharlagun? At Naharlagun in the state of Arunachal Pradesh shall be handed over to the registry of this court by the end of this month. We have taken note of such submission of Mr. Chandra. We find that there is no current issue that needs to be addressed insofar as state of Mizoram is concerned. First up, in view of the above, for the sake of facilitating the respective initiatives and or steps to be taken by the parties, we direct that this matter be posted again on 4th of August 2025 as fixed item.
One observation, Lordship, we make so far as the order in respect of state of Assam is concerned. This time the affidavit has been filed by the Judicial Department, because now on all affidavits will be filed by the Judicial. There is an internal arrangement that just me mentioned that.
So that's okay. It's state only. Judicial
Yes,
Department state.
absolutely.
So that's okay. There nothing hinges on these things. See, these are not adversarial litigations.
No.
So who has filed it or who has sworn in,
Should
as
come
long
from
as the
state.
purpose is served,
Yes.
that is fair enough.
I have only one submission with you.
Yes, please. Yes.
In fact, the purpose for which it is going to be utilized has been mentioned, my lord, in the letter itself. That is.
No, that is fine. That is fine. But
No,
in
what I
addition
want
to
to
that,
tell you, what I want to inform your lordship is, this is the payment which is coming for these three projects. Much more money would be required for the entire project. That is a separate thing. We are dealing with what we have received and we will do it. So
no, that's perfectly fine. That's
I just
perfectly
wanted
fine.
to, the lordship may mention just that this is the amount to be received for which we are going to go ahead.
At a line at Progata.
That is
Although
specified.
the learned AG has submitted, AG Nagaland has submitted that the money will be utilized for the purpose for which it has been sanctioned, as mentioned in the letter.
Yes.
Yet we deem it appropriate to observe here that Koripalai line to Logabo. That
No,
is,
sir.
we
That's
should not be diverted.
fine.
All right?
Public.
Yes. So, 11:15, single bench. Huh? There's another matter? What is that?
This is the review that was filed by the state.
Hmm.
The review which was filed by the state, my lord. Now, we made the paper publication and few of the opposite parties they have put in their appearance.
Hmm.
PDF copies we have given. You require hard copies, we'll supply that also because it was 800 some pages per page. Some have not appeared.
So has any appeal been preferred by the state against the judgment?
No.
No appeal.
No, by the state, no appeal. But some petitions have gone to the Supreme Court in SLP. That is what we have been told, but we have not received copies in the state as of now.
My lord, in this regard, the state has appeared before the Supreme Court and seeking 3 weeks time for filing their affidavit on
consider.
2nd February of 2025. The judgment is here, our order is here.
That's okay. That's okay. That the state will do. Whoever, you are the review, you are the SLP petitioner in Supreme Court.
Well, some of the SLP, there are several SLPs there.
Several SLPs. Okay, but Mr. Majumdar, then what you will also have to examine is that once SLPs are pending, till the SLPs are disposed of, can this court tinker with the order in any manner? Supposing
That part is there.
Supposing
Otherwise,
the court accepts that there is a ground for review,
Hello.
then also we cannot tinker with this order till the SLPs are disposed of either ways.
I'll have a discussion.
And the SLP can be disposed of by even addressing the issues of the state. So
I'll-
you must think about it. Because let us not complicate
What
issues.
was
further.
allowed in the petitions is what the state is agreeing with in the review. We have come up with that.
Hmm.
And the persons who are before the Supreme Court, if I understand
what was
correctly,
disallowed.
would be what was denied to them.
Correct.
So the issues would be totally different.
Correct. But if we tinker with this order,
My lord.
then the matter becomes matter before the
I
Supreme Court
understand.
gets affected.
This I was not.
Because if we review it, then the judgment does not remain the same.
Lordship should have this after the vacation time so that at least I can have a discussion with the AG also.
Yes.
Or-
After.
Hard copy.
We'll adjourn it for 6 weeks. Yes.
We have not received the hard copy, Lordship.
I said that. I have given all
Copy.
PDF.
I heard Mr. R. Majumdar and counsel appearing for the review petitioner. Also heard Mr.
SU Ahmed.
S.U. Ahmed and Mr. F.U.
AP
Borbia.
Borbia, response number 251 to 200.
You give it in a
Yes.
appearing for so and so. The other respondents have not yet put in appearance. Mr. Borbia submits that no copy of the review petition has been furnished to him till date. As such, on the request of learned counsel for the respondents, this matter be listed again after 6 weeks. Upon verification as to whether any new counsel has entered appearance for the respondents, for the remaining respondents. In the meantime, hard copy of the review petition be furnished to the learned counsel for the respondents. Yes. So we'll
Right.
see
Obvious.
11:15.
On Wednesday, my lord. Urgency is this, my lord. I am working as an assistant engineer in NIT. Petitioner approached before this honorable court in 2024. This honorable court protected the petitioner
Listing of repetition for what?
for orders, my lord.
You
Because
have to mention it in the coordinate bench. I will not pass any order of listing. Otherwise, you can enter it in the register, the system we are following.
but lordship is senior.
Are you aware of the system we are following in this? You ask her, she'll tell you, or ask him. It can be done without mentioning. You can put it in the register. Yes.
My please, your lordship, but I beg to mention item number 8, your lordship.
Hmm.
Lordship, this matter may not be taken up today, your lordship. I am mentioning on behalf of STC Council, Mr. R.M. Das, your lordship. It's not well today, your lordship.
Item number 8.
I have taken the concern, your lordship.
Who is for the petitioner?
K. Sharma. K. Sharma, I have.
All right, a prayer for adjournment of hearing of this case has been made on behalf of the National Standing Council, ASTC, on the ground that the arguing council is unwell and therefore has not been able to come to court today. Since the prayer is made with the consent of the other side, same stands allowed. List accordingly.
Obliged.
You have for respond number?
One.
Achha, so and so is for respond number. Yes.
Oblige.
Item number 9, I may be passed over for the bill. Item number 9. Can be taken up after vacation, Lordship, because I have
On the
misplaced the
request of
file.
Mr. Ardhar, Learned Counsel for the petition.
Lordship, I am there for the respondents, Oil India Limited.
Hearing of this matter stands adjourned for 2 weeks, least after vacation. Ms. Swami, Learned Counsel is present for the response.
Respondent, Oil India.
May I plead your lordship? I pray for the listing of an IA, your lordship, for correction of typographical error, your lordship.
When do you want it?
Tomorrow, your lordship. We have filed on 12th.
You do it on Monday?
Oblige, your
May I
lordship.
please, your lordship? Lordship, will you consider the other side? I beg to mention item number 6, your lordship. Let this matter become after vacation, your lordship.
So on the request of Mr. Arboro, Learned Counsel appearing for the writ petitioner. Hearing of this matter stands adjourned for 2 weeks, least again after the summer vacation.
Oblige.
It is your lordship. I beg to mention a matter for withdrawal.
When do
Withdraw.
you want it?
I'll leave it to your lordship's convenience. Tomorrow, I'm grateful.
Yeah, please, your lordship, I beg to mention for listing of WPC filing number 7060 for motion tomorrow, lordship.
What is the matter about?
It pertains to recovery from pensionary benefits.
So there is urgency.
Yes, lordship. Obliged, lordship.
May I please, my lord? My lord, I beg to mention item number 3, my lord. With consent of the other side, my lord, matter may adjourn, my lord.
You are appearing for whom?
Respondent, my lord, on behalf of DC Bora, my lord.
Lordship,
Yes.
for the petitioner, lordship.
Any objection?
Lordship, finally, a date may be fixed. 2016 matter, lordship.
After vacation, my lord, any date.
A request for adjournment of hearing of this case has been made on behalf of Learned Counsel for the respond numbers 1 to 5 on the ground that the arguing counsel is not available today. Mr.
A. Brahmo.
A. Brahmo has appeared for the petition. Learned Counsel has appeared for the petitioner and seeks a firm date of hearing in this matter. Taking note of the submissions made at the bar, this writ petition is directed to be listed again on 29th of July 2025 for hearing as a fixed date.
My lord. Obliged, ma'am.
Please, your lordship. That's why I'm praying for listing of this motion betterment. Can it be taken up on Tuesday, Monday or Tuesday? Anytime? Obliged, ma'am.
I beg to mention item number 2, my lord, with consent to the other side, my lord.
Item number
Kindly
2.
adjourn this matter for the day, my lord.
Again, they are
On behalf of SC business, man.
these are all old matters.
Old matter, my lord.
Why?
On behalf of SC business here, some personal difficulty, my lord.
Expressing
Please accept
personal
vacation, my lord.
difficulty on behalf of the arguing counsel appearing for the writ petitioner in this case, a prayer has been made to adjourn the hearing of this matter for 2 weeks. Mr. K.K. Parasar, Learned CGC appearing for respond numbers 1 to 6 has pointed out that this being an old matter, urgent and expeditious disposal of the writ petition is called for. Be that as it may, taking note of the submissions made at the bar, hearing of this matter stands adjourned till 29th of July 2025. Office to list the matter accordingly. Yes.
Lordship, pray for listing this matter for motion tomorrow, Lordship.
What is the matter?
Pensionary benefit, Lordship, regarding pensionary benefit.
Monday.
Lordship, considering the urgency.
Sorry?
Lordship, considering the urgency, there were 4 WPCs which were listed yesterday, but which. Lordship, actually there were 4 WPCs which are supposed to come yesterday, but it was not in the list. Kindly list the matter on.
You go and make that request to the register. Seek guidance from her. He'll tell you.
Wait, please, your lordship, with the consent of other side, I beg to mention item number 4. Conducting counsel, Mr. B. Pathak has a personal difficulties.
The prayer of Learned Counsel for the writ petitioner made with the consent of the other side. Hearing of this matter stands adjourned for 3 weeks. List accordingly.
I am for respondents in this matter.
Ms. S. Burwa, Learned CGC is present on behalf of the respondents.
Your lordship, my lord, kindly allow me to withdraw the petition, my lord, because I have made some mistakes, my lord. I want to file a fresh, my lord. Quickly, but
Mr. M. Sekhar, Learned Counsel for the petitioner submits that there is some defect in this writ petition which call for rectification. First of, therefore, the petitioner be permitted to withdraw this writ petition with liberty to file afresh. The prayer is not opposed by the learned. The prayer is, since the prayer is unopposed, same stands allowed. Writ petition stands disposed of on withdrawal with liberty as spirit. Yes.
Lordship, they had filed in, state has filed an IA because Lordship had given a direction to file the affidavit within 25th. Otherwise, Lordship say that no application, no affidavit shall be allowed.
Lordship, Senior Counsel D. Mojumdar is on legs, Lordship.
All right, call him, let him come.
State Bank matter, Lordship, had this matter, before yesterday, my lord.
Yes.
My lord, shall I from the beginning or shall I start or from where shall I start, my lord? I don't know. Because
Wherever
Lordship,
you want to start, Mr. Nath, I will be there with you. You decide the starting point and the ending point.
that's what, my lord. In that case, my lord, this matter was heard by your lordship once, judgment was passed, the writ appeal was filed against the judgment, my lord, only a small ground that I produce certain documents, two documents before your lordship, that's saying that, my lord, I am in selection number 2 and the other person is selection number 1. On those selection was made just for filling of temporary appointment. But selection number 1 was appointed regularized. They are, my lord, the grade 4 employees, Jamadar, they are, my lord, sweeper there. So, but hearing time, my lord, I told you, lordship, I placed the document saying, my lord, kindly see my number is serial number 2 and serial number 1 is another person. He has been regularized, he getting the full salary, my lord. Now, if they say that is for the temporary post, it will be applicable to everyone like this. Now, number 1, you appoint him temporarily and select him, regularize him. Then your lordship said yes. There is a disparity. Lordship passed the order to regularize me also. So when I produced those two documents, my lord, it was not in the pleading because I got on the previous night of a hearing, my lord. So the writ appeal was filed solely on the ground that on the day of hearing, my lord, that was not in the pleaded in the writ petition. I said, yes, it was not pleaded, my lord. That's why, my lord, the matter was sent back that you file an affidavit, extra affidavit, including those documents before the single judge will dispose of. This is the matter that has come up, my lord. Now, if your lordship, my lord, page number judgment is, my lord, this in page number 60, my lord. Page number 70. 70. Yes.
Yes. Let us read the judgment once.
Yes, my lord.
Yes.
Second paragraph. The petitioner's previously stated is that pursuant to selection process based on interview, the petitioner was empaneled at serial number 2 in the panel of grade 4 employee who are required to be employed under the State Bank of India on temporary basis as general attendant sweeper in the district of Kachar. There were altogether 3 candidates whose names figured in the panel notified on 26/24 by the Assistant General Manager, SBI Regional Office Silchar, and the petitioner's name appeared serial number 2 in the panel. Pursuant to the preparation of the panel, the petitioner was allowed to join the general attendant in the SBI Kachar Silchar branch with effect from 15/6/04 on the basis of an order of appointment dated 16/6/2004 issued by the branch manager. Since then, the petitioner has been continuously serving as general attendant. As a matter of fact, at the instance of the respondent authorities, a provident fund account of the petitioner was also created by the Provident Fund Pension and Gratuity Department of the SBI. Such as submits that petitioner has been continuously serving in the post of general attendant on temporary basis since the year 2004. Notwithstanding the same, that despite the fact that persons above him in the panel, the Shubhendu Kumar Nath, has already been regularized in service, no action has been taken by the bank to regularize petitioner's service, although he was rendered more than 19 years of continuous service till today. That apart, the submit that petitioner also has not been paid his salary since the month of March 2010 till today. Hence, this petition seeking for such and such. Mr. Talukdar submits that petitioner was empaneled due to intervention of some of the senior officials of the bank who were at the helm of officers at the relevant point of time. However, it is not a fact that petitioner had served as general attendant all along since the date of appointment on 15/6/04. Mr. Taluka submits that in between, the petitioner was relegated to the position of a daily wage earner, and therefore it cannot be said that he has rendered continuous service in the post of general attendant since the year 2004. By relying on the decision of the Supreme Court rendered in such and such, Mr. Taluka submits that unless the appointment was made on regular basis after due selection, the question of regularization in service does not arise in the eyes of law. I have considered the submissions made by bar and have also gone through the materials available on record. At the very outset, it needs to be noted that here, the appointment of the petitioner was evidently made on the basis of his position in the panel notified by the SBI authorities on 26/2/04, wherein the name of the petitioner appeared at serial number 2. The panel was evidently prepared on the basis of names being sponsored by District Employment Exchange and after subjecting the candidates to interview. It is not in dispute that at the relevant point of time, the filling up of grade 4 post on the basis of names sponsored by the concerned District Employment Exchange was a permissible and acceptable mode of recruitment. Thereafter, the petitioner was allowed to join in the post of general attendant on the basis of appointment order dated 15/6/04. It may be correct to say that appointment of the petitioner was made on temporary basis, but materials on record, more particularly the communication dated 7/4/09, goes to show that appointment of the petitioner was made against the post which had fallen vacant due to demise of a permanent sweeper of the bank, Premlal Balmiki, who had died on 2/12/03. Therefore, there is sufficient materials for this court to presume that appointment of the petitioner, although was made on a temporary basis, was against a permanent vacancy. Subsequently, respondent might have shifted the petitioner from one position to another, and it also appears that at one stage, the petitioner was allowed to draw only daily wage by denying him the salary and allowances. However, there is nothing on record produced by the bank to indicate the basis on which such treatment was meted out to the petitioner. It is to be borne in mind that grade 4 employee appointed on a temporary basis will have a very little bargaining power when it comes to assignment of a duty or to him by the authorities, as he or she might be in constant fear of losing their job if he or she raises the protest against the treatment meted out to the authorities. That Brajaran Ganguly case, my lord. Therefore, unless action of the bank in contravention when converting the petitioner's temporary appointment to a daily wage earner is found to be justified under the law, no credence can be given to such conversion in the eyes of law. In the present case, the learned counsel for the bank has failed to produce materials to show that appointment of the petitioner in the post of general attendant on a pay scale was subsequently converted to a job of a daily wage earner. On the contrary, it is not in dispute that the petitioner has been continuously engaged in the service of the bank since the year 2004 till today. Therefore, this court is unable to accept the submission of the learned counsel for the respondents that appointment of the petitioner was earlier illegal or irregular, or that there was a break in service so as to deny him the benefit of regularization. Law is no doubt settled that regularization cannot be claimed by an employee as a matter of right. However, it is equally settled that denial of benefit of regularization to one employee for extending preferential treatment to another would not be illegal, but also discriminatory in the eyes of law. As noted above, the person appearing in serial number 1, Shubhendu Kumar Nath, has already been regularized in service after his initial appointment as general attendant. However, even after rendered continuous service for more than 19 years, today is 21 years, the respondent bank had denied similar treatment to the petitioner without there being any justifiable ground to do so. As such, I am of the view that petitioner has made out a good case for interference by this court. The writ petition therefore succeeds. The petition disposed of with the direction upon the respondents to forthwith take necessary steps for regulation of service petitioner against the post of general attendant. In so far the prayer for release of the arrears salary is concerned, the respondent may make an inquiry into the matter if found due the arrears salary of the petitioner be released, subject to, however, to application of law of limitation in this regard, which would debar the claim of the petitioner to claim arrears salary beyond the period of 3 years from the date of institution of this petition. This is disposed of. Against this, my lord, next page, the writ was filed, my lord. And this was the judgment order passed on 3/10/23, page number 76. My lord, heard such and such. The instant intra-court appeal, writ appeal is directed against the judgment final order dated 16/6/23 passed by the non-single judge, whereby the writ petition being number such preferred by the respondent herein was accepted and the appellant bank was directed to regularize his services. Mr. Chaudhary, such and such for the petition respondent representing the appellant submits that direction to regularize the service of the writ petitioner was issued purely drawing parity from the fact that another employee, namely Shubhendu Kumar Nath, had been regularized in service after his initial appointment as a general attendant. Now, the counsel also submit that this ground was not pleaded in the writ petition and hence the appellant never got an opportunity to counter the same. He has referred to several aberrations in the writ appeal explaining the reason by which case of the respondent writ petition is totally distinguishable from the Shubhendu Kumar Nath. Representing the correspondent not in a position to dispute the submission of Mr. Chaudhary that no pleading was made in the writ petition claiming parity in the case of the appellant and Shubhendu Kumar Nath. However, his submission is that the petitioner has several other reasons grounds for seeking direction to regulation. Having considered the submission advanced at the bar, we are of the opinion that in the writ petition there was no aberrament regarding regularization of services of Shubhendu Kumar Nath and the claim for relief of parity on appellants herein were precluded from responding to the pertinent ground on which the writ petition was accepted. That's the ground. At this stage, London Senior Counsel representing the response submits that no purpose would be served by keeping this appeal pending in the court. Court may be pleased to demand the matter such and such liberty to the respondent to file initial affidavit on the ground to which Chaudhary Mr. such and such, my lord, no object. In the wake of discussion made herein above, the impugn order dated 16/6/20 reverse. Matter is remitted to the London single bench for fresh consideration and decision of the writ petition on merits. The respondent writ petitioner shall be at liberty to file additional pleadings to project this cause on the basis of parity with Shubhendu Kumar Nath. This appellant bank will be given liberty to file an affidavit in opposition if so desired, my lord. Thereafter, my lord, I have filed this affidavit, my lord, annexing the documents, my lord. My lord, that will be in page number, it starts from page number 46, my lord. In page number 46 starts, page 54 is the judgment of the division bench. And then those two documents which I produced before lordships, my lord, that lordship will find in page number 58.
There is no pleading about what?
There's Shubhendu Kumar Nath. Those two documents was in serial number 1.
What? We'll ask them, but
Yes.
what is the projection? There is no pleading in the writ petition.
Yes, that pleading means kindly come to page number 54. I'll show what's there. Come 54. I'll show, my lord. 54, not 54, 58. 50 and 60, 59, these two documents. Those two documents I produced at the time of hearing, my lord. Just to show parity. These two documents.
That's not the question at all.
So
there is no pleading according to what is appearing. There is no pleading that Shubhendu Kumar Nath had been regularized in service after his initial appointment as a general attendant. That pleading is not there.
That was not there. I produced those two documents at the time of hearing because it was previous night. I just told the lordship, my lord, this is what can we say. And this I have, by the of this affidavit, I filed, my lord. And now it is there in page number 58 and 59. Kindly see 58, his appointment letter, my lord. I've got type copy. I've got clear copy, type copy. Page 58. This is a clear copy. Type, my lord. Top right side, my lord. Top right side, Shubhendu Kumar Nath. Of Shubhendu Kumar Nath, general attendant. And in the left side, my lord, fourth line, R04 staff. Lordship has seen, my lord, this staff. This number you lordship will find in the select list. This number is there. R4 staff. Same select list where he appears number 1, I am number 2. So with reference to the interview held on 20/1/24, both he and me on the same day appeared. For selection of general attendant, you have been found suitable for appointment as general attendant. Sweeper such and such. It is therefore been decided to appoint and post of Kabuganj branch. Please therefore report to the branch manager doing such and such. Can you see the next page now, my lord? 59 page number. His salary. 59. Top left, Second, name Shubhendu Kumar Nath. Basic pay, dinner allowances, house allowances, special allowances, transport, washing machine, washing allowances, allowance, all these things comes together, my lord, 17,844, and take home something like, my lord.
Where is the initial selection? Your
Yes,
original
my lord,
panel?
page number 15 is the select list, my lord, kindly see. Page number 15, kindly is the series, call letter, that number, see that from the, let us see from the call letter, page 15. On the left side, my lord, kindly see, there is a number, R4 staff, same number there in his appointment letter, first one, this number. Kindly see on 9104, right side top, Paplunath, my client. General empanelment for temporary appointment of general attendant sweeper interview. It has been decided to hold an interview in connection with preparation of a panel list for temporary appointment of general attendant on 22-104. Silchars, your name has been sponsored by District Employment Exchange for the purpose you are requested to appear before the interview board such and such. Click on certificate. Then next page number 16 is a select list. It is a type copy. The original is the bottom. Page 16, my lord. 26-204 select list. Staff subordinate preparation of panel for temporary appointment of general attendant sweeper for the district of Kachar. With reference to the above, we have to advise that in interview for the preparation of a panel list for temporary appointment of general attendant at the branches of Kachar district was held on 22-104 at his office. The list of successful candidate in order of merit along with their permanent address are furnished here and below. Number 1, Shubhendu Kumar Nath. Number 2, myself. This is what, my lord. Now kindly see the next page number 17. Seal number 2. Therefore, arrange to make necessary arrangement for replacing the existing temporary general attendant, if any, presently working at your branch from the above panel list, and also note to utilize their services on purely temporary basis whenever necessity arises in future, and as such as leave, death, retirement, etc. As the new panel will be enforced with immediate effect, the old panel is cancelled. I am in the death vacancy, have been appointed. That's in page number 20. Page number 20. As per regional office panel list for temporary appointment, you are hereby temporarily appointed as general attendant at the branch of effect on 15604. Now, this is for a permanent post. I was kindly see page number 27 now. The person in the permanent employee, he expired, he died on sweeper. In that post, I will have to work. Kindly see page 27. 7509. Page 279. Dated. My lord. To the general manager, State of India, salary of general attendant. With reference to the above, we beg to advise that C. Paplunath has been appointed on a purely temporary basis as a general attendant sweeper full-time on 15604 on the demise of a permanent sweeper, Sri Premlal Baimiki, who died on 2/12/03 from the panel list of appointment of general attendant sweeper for the district of Kachar, which was prepared by at the regional office Silchar, and the same has been circulated to branch on 26/204. We are since utilizing his services on purely temporary basis, full-time sweeper. His salary and allowances being paid by department by to charge account salary allowances till March. Such a salary for the month of April has been paid, my lord. So total he gets, my lord, 6,277, my lord. This is what. Now next page, they sought for approval of the petitioner, my lord. Next page, page number 28. The branch manager, the chief manager administration. Subordinate staff appointment with reference to the Silchar branch dated such and such. My lord, duplicate copy of the has been forwarded to you. In this context, we have to advise that appointment of temporary general attendant has already been stopped by the bank, Long Bank. We shall therefore request you to forward a copy of the appointment letter and also copy of the head office approved if any, in the instant case, to take up the matter with the appropriate for such as, my lord. This is what. Now, my lord, subsequently, they send me to the another branch on a daily wage basis. Then I made a prayer to them, kindly pay my salary in all, my lord. In this case, lordship will find, my lord, they have taken one plea because there are other papers not that much relevant. What plea they have taken? In my petition, I have stated that I have, before my selection, I work about 3 years. Now, they came with the affidavit. Now, the last affidavit, they said, no, he was working, being appointed by local implementation committee. My lord, I want to submit, my lord, before selection, whatever job I did or he did, it has got no relevance at all. Number one reason is, in my case, they have taken a plea. He was appointed by the local implementation committee. Is that got no meaning, as Supreme Court says? But if a losses find in paragraph page 65, there also they stated the other fellow Shumindranath also working under the local implementation committee. So we are similarly situated, and I submit that selection before the interview has no relevance. If it is private to private, for him, for me, it's all right. No material. Question is, our names were forwarded by the employment exchange. Those days, it was permissible. He was number one, I am number two. Now they say, no, he's been regularized, I can regularize. That's why, my lord, I have shown these are documents before lordships. Now, my lord, kindly just have a look at one judgment, my lord. Can you look on judgment, my lord? Almost the way lordship has passed the judgment, the Supreme Court has passed that judgment only. In Jaggu case, that was passed on 20/12/04. Para 20 on this subject, but let me read from paragraph 20, my lord, last part, one page. Last part, one page, paragraph 20. It is well settled. It is well settled. My lord, paragraph 20, let me read. It is well established that the decision in Uma Devi does not intend to penalize employees who have rendered long years of service fulfilling ongoing and necessary functions of the state or its instrumentalities. Said judgment sought to prevent backdoor entries and illegal appointment that circumvent constitutional requirements. However, where appointments were not illegal but possibly irregular, and where employees have served continuously against the backdrop of sanctioned functions for a considerable period, the need for a fair and human resolution becomes paramount. Prolonged, continuous, and unblemished service performing tasks inherently required on a regular basis can, over the time, transform what was initially ad hoc or temporary into a scenario demanding fair regularization. In the recent judgment of this court in Binod Kumar and others, it was held that the procedural formalities cannot be used to deny regularization of service of an employee whose appointment was temporary, the term temporary, but has performed the same duties as performed by regular employee over a considerable period of in the capacity of regular employee. 21 years I have appeared on today, my lord, from 2004. The relevant paragraph of this has been put below. My lord, this one, lordship may come to paragraph 21, my lord, paragraph 21. Main is 26. The High Court placed undue importance on the initial level of the appellant's engagement in the outsourcing decision taken in their dismissal. Court must look beyond the surface level and consider the realities of the employment, continuous long-term service, indispensable duties, and absence of any malafide or illegalities in their appointment. In that light, refusing regularization simply because their original terms did not explicitly state so, and because an outsourcing policy was belatedly introduced, would be contrary to principle of fairness and equality. My lord, the 22, the pervasive misuse of temporary employment contract as exemplified in this case reflects a broader systematic issue that adversely affects workers' rights and job security. In the private sector, the rise of the gig economy has led to an immense increase in precarious employment arrangement, often characterized by lack of benefit, job security, and fair treatment. Such practices have been criticized for exploiting workers and undermining labor standards. Government institutions entrusted with upholding the principle of fairness and justice bear an even greater responsibility to abet such exploitative employment practice. When public sector entities engage in misuse of temporary contract, if not only mirror the detrimental trends observed in the gig economy, but also set a concerning precedent that can erode public trust in government operations. The International Labour Code, of which India is a founding member, has consistently advocated for employment stability and the fair treatment of workers. The ILO's Multinational Enterprise Declaration encourages companies to provide stable employment and to observe obligations concerning employment stability and social security. It emphasizes that enterprises should assume a leading role in promoting employment security, particularly in context where job discrimination could exacerbate the long-term unemployment. My lord, this is about the American Supreme Court also they have quoted, paragraph 24. The landmark judgment of the United States in the case of such serves as a pertinent example from the private sector, illustrating the consequences of misclassifying employees to circumvent providing benefits. In this case, Microsoft classified certain workers as independent contractors, thereby denying them employment benefits. The US Court of Appeal for the Ninth Circuit determined that these workers were, in fact, common law employees and were entitled to the same benefit as a regular employee. The court noted that large corporations have increasingly adopted the practice of hiring temporary employees or independent contractors as a matter of avoiding payment of employee benefits, thereby increasing their profits. This judgment underscores the principle that nature of work performed rather than label assigned to the worker should determine employment status and the corresponding rights and benefits. It highlights the judiciary's role in rectifying such misclassifications and ensuring such workers receive fair treatment. My lord, paragraph 20, how misuse, arbitrariness and such, please come to paragraph 26 is the relevant, my lord. While the judgment in Uma Devi sought to curtail the practice of backdoor entries and ensure appointments adhere to constitutional principles, it is regrettable that its principles are often misinterpreted or misapplied to deny legitimate claims of long service employees. This judgment aims to distinguish between illegal and irregular appointments. It is categorically held that employees in irregular appointments who were engaged in daily and duly sanctioned posts and had served continuously for more than 10 years should be considered for regularization as one-time measure. However, the laudable intent of the judgment is being subverted when institutions rely on its dicta to indiscriminately reject the claim of employees, even in cases where the appointments are not illegal, but merely lack adherence to procedural formalities. Government departments often cite the judgment in Uma Devi to argue that no vested right to regularization exists for temporary employees, overlooking the judgment explicit acknowledgement of cases where regularization is appropriate. This selective application restores the judgment's spirit, purpose, effectively weaponizing it against employees who have rendered indispensable services over the decades. In the light of these considerations, in our opinion, it is imperative for government departments to lead by example in providing fair and stable employment, engaging workers on a temporary basis for extended period, especially when their roles are integral to the organization's functioning, not only contravenes international labor standard, but also exposes the organization to legal challenges and undermines employees' morale. By ensuring fair employment practices, government institutions can reduce the burden of unnecessary litigation, promote job security, uphold the principle of justice and fairness that they are meant to embody. This approach aligns with the international standards and set to positive precedents for the private sector to allow, thereby contributing to the overall betterment of the labor practices in the country, my lord. Here, lordship is seen, my lord, from 20, it is now today's 21 years I've calculated he is working, my lord. And the Premlal Balmiki was a regular employee, he's died, in his place I was appointed, my lord. So I'm working continuously, my lord. And that's the reason lordship is actually, in fact, the judgment not there, but the language lordship used, this is the language, my lord, in this judgment. Only my lord came subsequently, lordship judgment came earlier. That's the difference.
My lord, in our affidavit, my lord, we have shown that, my lord, there is no parity between the petitioner and Shibendu Kumarnath. If your lordship kindly takes up our affidavit, we have stated, my lord, how he came to be regularized and not the petitioner. May I, my lord, draw your lordship attention to my affidavit, additional affidavit after my lord remand.
It starts at page 60. My lord may come to page 63, paragraph 10.
Paragraph
10. Page 63.
yes.
That with regard to the statements in paragraph 6, the deponent offers no comments insofar as the same is a matter of record, except the fact that the said letter is very much clear on the aspect of selected candidates, including petitioner, will not get protection for employment in bank service, as evident from the said letter. Then paragraph 12, that with regard to the statements made on the paragraphs 8, 9, and 10, the deponent begs to state and submit before this honorable court that while it is not in dispute that Premlal Balmiki, since deceased on 2/12/2003, was an employee with the State Bank of India, the service of the writ petitioner, however, was not made against the said vacancy. The writ petitioner, along with the selected candidates, including Shivendu Kumar Nath, as reflected in the order dated 26/2004, Annex 3 to the writ petition, were selected temporarily as general attendant, and their services were to be utilized by various branches of the State Bank of India in Kachar district on a purely temporary basis whenever necessity arises in future, such as leave, date, retirement, etc. The said order further clarified that no such selected candidate was to get protection for employment in the bank service. Then para 13, that it may be stated that be that as it may, the Shivendu Kumar Nath was subsequently regularized, and the case of the Shivendu Kumar Nath cannot be equated with that of the writ petitioner inasmuch as the two are not similarly situated. Unlike the writ petitioner, Sri Shivendu Kumar Nath had been working as a canteen boy from September 1990, and thereafter he worked as a cleaner with the bank in the year 1997. It is pertinent to mention that before 15/6/2004, the petitioner never worked with the bank, though he is a casual worker with local implementation committee of the branch. It is submitted that the Honorable Apex Court has already decided the controversy, holding that the employees of the canteen, which are run at various branches by the local implementation committee, as per the welfare schemes framed by the SBI, would not become employees of the bank, as the bank is not having any statutory contractual obligation arising under the award to run such canteens. That a settlement dated 30th July 1996 between the State Bank of India and All India State Bank India Staff Federation was arrived at, where it was clearly stated that while temporary employees in subordinate cadre out of panel so prepared were to be given a chance for being considered for permanent appointment in the bank against vacancies arising up to December 1994, daily wage casual employees out of a panel so prepared were to be considered against vacancies arising from January 1995 to December 1996, whereafter the said panel would lapse. The deponent submits that even though the date of Premlal Balmiki occurred after the cutoff date of January 1995, it is pertinent to mention that Shivendu Kumar Nath was the only candidate in the list dated 26/2004 who had been working for the bank prior to March 1997. That is the cutoff date for consideration for regulation by the bank. The aspect of regulation of Shivendu Kumar Nath was based on equity on having been worked as a canteen boy with local information committee in the branch of the bank from September 1990, as well as working as cleaner with the bank since the year 1997, and the same cannot be construed as a rule to bring parity with the selected candidates. Now, my lord, may I take your lordship to the agreement that was arrived at between the Federation and the SBI, that your lordship finds at page 79. This is a settlement dated 30th of July 1996 between the State Bank of India and All India State Bank of India Staff Federation. Now, your lordship may come to the next page, page 80, my lord. Second paragraph. Whereas in terms of the aforesaid settlement, there were, my lord, three other earlier settlements have been referred to, 4 settlements. Whereas in terms of the aforesaid settlement, while eligible temporary employee in subordinate cadre out of a panels who prepared were to be given a chance for being considered for permanent appointment in the bank against vacancies arising up to December 1994, daily wage casual employees out of a panels who prepared were to be considered against vacancies arising from January 1995 to December 1996, whereafter the said panels would lapse. Whereas in terms of the minus of the conciliation proceedings held on the 9th June of 1995 before the Regional Labour Commissioner Central at Hyderabad in partial modification of the earlier settlement, it was agreed that both the panels of temporary employees and daily wage casual employees will be kept alive up to March 1997 for filling up vacancies existing arrived at on 31st December 1994. As per the norms agreed to between the bank and the federation, and the identification of managerial messengeril vacancies would be done with effect from 1st April 1972 on the basis of the new norms to be finalized in the meantime. It was also agreed that the modalities about drawing names from either the panel of temporary employees or panel of daily wages and casual labor would be decided administratively on circle to circle basis depending upon the local requirement in consultation with the federation's affiliate by the circle management. It was also agreed that all the managerial positions in the subordinate cadre, including part-time attendance, specifically provided at level reserved, will be filled before 31st March 1997. Now, my lord, the Sibendu was the only person in the panel who was working prior to March 1997. And my lord, the petitioner was, my lord, engaged from my lord 2004. So, my lord, this is regarding the parity. So, for the law, my lord, regarding the regularization of persons who have been working on a long-term basis, my lord, my learned friend has relied on Jaggu's case. On that, my lord, the principles that have been laid down, my lord, I do not have anything to dispute that. My lord, they were terminated, and thereafter, my lord, this judgment came, and the Uma Devi's case has been, my lord, explained. So, my lord, what I am on is that, my lord, the earlier order was in respect of judgment of your lordship was in respect of the, my lord, parity between the two persons. The parity is not there. But the
Was that the only ground on which the petition was allowed?
Yes, ma'am.
Only ground? That was the only reason why the writ petition was allowed.
Your lordship has discussed other points, but finally, my lord, your lordship has come to that since this person has been regularized, he is the serial number 1, he is serial number 2. That was the
other observations of the court have not been set aside.
My lord, on that, the honorable my lord, division benches sent it back.
So you understand now it is not possible for this court to take a different view.
Because of this.
What happened? He's sympathetic, but the problem is the bank. Otherwise, his heart is like me. Because the sweeper.
We are on technical legal issues.
Yes, ma'am. I don't have
made an observation that there is a parity. In the
Yes,
sense
ma'am.
that one person, parity word has not been used, but
Yes.
one person having been regularized.
We have
So,
taken advantage of that.
Just for your satisfaction.
My lord.
Otherwise, there is no need for me to spell out these things. First of all, what you have pointed out, these are reasons for you to deal with one case in a particular manner and another case in another manner.
My lord.
Parity is a matter of legal principle, not reasons. You may have hundreds of reasons to pick someone for some reason, not to accept somebody for some reason. But these are the justification of the bank on facts. Question of parity is a matter of law. Here the issue, as I could see, of course I will have a second look at the judgment, was that you have followed a process, selection process, you have prepared a panel.
My lord.
You did not appoint him because he was appointed before 96. You appointed him because he was serial number 1 in the panel.
Yes.
Number 2, the fact that both of them are part of the panel and it was prepared by the authorities and both of them were temporarily appointed, that aspect has not been disputed by the bank.
Yes.
So therefore, yesterday, day before yesterday, your junior was there. I was saying this matter perhaps should not have come back on a plea of the bank on this ground. On a legal point, whether he is entitled to be regularized or not, that's another matter. That the bank has a right to take that plea. But leaving aside everything just on the ground that there is no pleading as regards parity, what is the pleading? The fact remains that these are all part of the same panel. One is number one is number two, same process. That is where the court had drawn parity. Not because who came in for how many years. That was not the criteria for the bank also.
Your lordship is right, but
In that context, I'd ask this that is it not a case where you're making the judge work twice on the same brief for no valid reason? And if it is so, why should the court not impose some cost? You have every right to question an order and take any plea before a higher forum on merits. The larger bench may accept your plea, not accept your plea. But look here, what is the plea that the bank has taken here? The plea is that there may be parity or there may not be. But the fact is there is no pleading. Now, are we dealing with civil suits where rules of pleadings? If that is the case, then what is the pleading in the counter affidavit? That's evasive denial. Evasive denial amounts to admission under Order 8. So should we employ all these principles? The fact of the matter is that this Shibendu Nath or whatever his name is, was at serial number 1 and the petitioner was at serial number 2. Both of them were empaneled and then they were appointed as temporary appointees. One of them is regularized. The other one is saying, consider my case for regularization. So the court has held that both of them were empaneled and both of them were appointed temporarily. One has been made permanent. Therefore, legal principles will warrant that the other should also get same treatment. Coupled with that, the other things have been discussed by the court. That these employees don't have bargaining power, having rendered long years of service. So let us take it that they are not at par. Then also, these judgments, Supreme Court judgments comes into play.
true. That is true, my lord. What I am always, my lord, only submission is that, my lord, since it was not pleaded, we could not have brought this, my lord, the federation agreement with the federation. And that is, my lord, a little law point is also involved in in that, my lord. The federation has agreed to it, and my lord, on the basis of that agreement only, my lord, the Shibendu was.
As I said, that could be your reason.
Yes.
But that reason doesn't change law.
My lord, no, so far as my lord regulation is concerned, my lord, now your lordship.
Then why did you empanel him? You should have straightaway regularized him. If the regularization, as you are trying to, is under the settlement, why did you empanel him? Why did you subject him to a fresh selection process and empanelment? If your argument could have had some basis, had you directly appointed him and the petitioner, you had kept him pending as an empanel.
My lord, in fact,
but you follow
this agreement, my lord, this agreement between the, my lord, federation and the SBI, also, my lord states that about a panel, my lord. It says about a panel because, my lord,
then why did you include him also in the same panel?
No, my lord, there is a cutoff date. That is the one.
Anything else, Mr. Chaudhary?
This, my lord, this needs to be considered by your lordship, and my lord, so far as the law regulation is concerned, I will not make any submission, my lord.
Just take the appeal. I'll dictate the order. I'm allowing the repetition. You'll get the order by tomorrow or day after.
Yes. Okay.
Yes, Mr. Majumdar.
Well, this matter has come up with an IA. In fact, the IA had to be filed because we filed the affidavit on behalf of the respondent. But earlier there was an order by your lordship that unless the affidavit is filed within a particular date, you will waive your right. So, my lord, we are praying in the IA that that order may be slightly modified to accept the affidavit in opposition which we have filed, so that the matter can be
What
taken up on.
cut-off date given?
My lord, I had to quote
25-4.
25-4, my lord. We have,
And it was filed on?
it was filed on, my lord. 30th of April, my lord. And this is the reason is, my lord, they had to obtain some clarification from another department that we have mentioned. Skill and Employment Department.
So you have received a copy of the affidavit?
I have received a copy. I just want.
Affidavit has been filed, just a minute, has been filed by respondent number?
Respondent number 2, my lord.
Respondent number 2. His application also along with the affidavit. Both were filed on first.
Yes. We'll allow them 5 days time.
Only thing is, I just want to place few facts absolutely up to your lordship's discretion.
You are opposing it.
I'm
You
just
should have
placing.
filed an objection.
No, I'm not.
I'll not.
I'll
Why are
not-
you wasting your time
Yes.
and my time?
But they had the instruction on second.
Maybe you have not filed any objection.
I agree to that.
So whatever is you have admitted, I'll record that you have accepted it.
No,
If
my
you
lord,
want to oppose, then you have to file objection.
in fact, without filing my objection, I can make a submission
No,
because it
no,
will be on
no.
their record only. I
No,
can say.
no. It's a question of shutting out their right to file.
Absolutely, but they have already filed an affidavit. That is
Are
why.
they not entitled to know what is your objection?
No, my lord, why? That is why. Just give me 2 minutes. I'll just place one fact. The affidavit in opposition was already filed. It is not that they are filing a fresh affidavit in opposition. The only issue came because they came up with an instruction that why my candidature was rejected. My candidature was rejected on the ground that I'm not an original inhabitant because I'm married to, she's married to an Assam person from Assam and she was not born in Assam and that way she was not treated to be original inhabitant. That on that question, this honorable court put a question that what is the meaning of original inhabitant? You put a office record or memorandum or something. Then respondent came up with a prayer that they will file an affidavit. So that affidavit was to be filed, which your lordship directed to file on 25-4. They say the instruction. Now the instruction which they are asking is from Employment Exchange Board with respect to the registration. In fact, in the entire affidavit, there is no meaning given about the original inhabitant or anything as such. It is completely new story which has been developed. So new facts have been placed in the affidavit, and that is why I'm just saying that my right to oppose that affidavit may be kept reserved. Because that application
It's always there.
because that affidavit, that will be a second affidavit. That's a second affidavit. It is not that affidavit in opposition was not filed.
No, he is only seeking that
that-
timeline of 25
Yes.
April should be made 30th.
But no explanation is given in that application. That's if your lordship sees it, that's up to your lordship. There's no explanation
There
given.
is no opposition from you also.
Lordship will see whether there is explanation given or not. It is our lordship discussion. I'll not say anything.
All right. I heard Mr. D. Majumdar and its senior additional AG for the state of Assam, assisted by Miss D. Devi. Devi or Devi?
Devi.
Devi. Learned counsel appearing in this case for the applicant. I have also heard Mr. Chaudhary, Mr. K. Chaudhary, learned counsel appearing for the opposite party. Full stop. By order dated 3/4/2025, passed by this court in the connected writ petition, the respondents were granted time till 25th of April 2025 to file counter affidavit by serving advance copy upon the counsel for the writ petitioner. First up, the counter affidavit as permitted by this court by order dated 3/4/2025 would ultimately be filed by the respondent number 2 only on 30/4/2025, which was exceeding the timeline indicated in the order dated 3/4/2025. As such, the present application has been filed seeking modification of the order dated 3/4/2025 with a prayer before this court to accept the counter affidavit filed by the said respondent. First step. The opposite party has not filed any objection. However, by making oral submissions, Mr. Chaudhary has opposed the prayer made in the IA by contending that there is neither any plausible explanation for the delay nor has the reason cited in the application have any reasonable nexus with the prayer made in the IA. Full stop. Mr. Majumdar, on the other hand, submits that since this matter has a important bearing, the counter affidavit is required to be considered by this court before arriving at a decision in the writ petition. Therefore, for ends of justice, the counter affidavit be taken on record. After hearing the submissions made at the bar and after taking note of the statements made in the IA, this court is inclined to accept the prayer made by the state. First, as such, the counter affidavit filed by the respondent number 2 on 30/4/2025 is directed to be taken on record. The order dated 3/4/2025 stands modified accordingly. It is needless to state herein that the writ petitioner would be at liberty to file rejoinder in response to the counter affidavit filed by the respondent number 2, if so advised. I still dispose.
Any date for the writ petition?
Now, if
Petition,
you,
get
if
the
you,
writ
if you want to
petition.
file a reply, rejoinder, let me file the
When will you
rejoinder.
file?
I'll file it within 1 week or 2. But
Mr.
then
K.
petition
Chaudhary,
will-
learned counsel for the petitioner, Mr. So-and-so, learned senior additional AG for the state of Assam. On the request of petitioner's counsel, office to list this matter for admission hearing as a fixed item on 22nd of July. When do you
Yes.
want it?
When?
Not- Is it possible 17th of July?
17th of July.
17th.
17th of July.
Earlier. Interim may be continued.
What is the interim?
There's an interim order to keep one post vacant.
Interim order operating in this case to continue till the next date.
Well, in place of counter affidavit, Lordship may say additional affidavit. This is additional.
Additional.
Fine. Oblige.
Obligement.
Not counter, additional. Five, none appears for the petitioner when the matter is called up for hearing. Mr.
B. Das, my lord.
B. Das, learned counsel is present for the respondents.
APTCL, my lord.
Non-standing counsel APDCL is present for the respondents. Since the petitioner's counsel is absent today, list the matter for hearing again after the reopening of summer session.
Obliged, my lord.
No, this is a matter, this petitioners were appointed, as contractual basis, they were appointed as computer assistants. Well, initially the advertisement was for the block data manager, and they were all selected. Now, they were of course under the waiting list. After some people were appointed as the block data manager, while giving them appointment, though they were selected as in the waiting list, they were selected as the block data manager.
Lordship will find that the results, my lord, page 28 onwards, my lord. The merit list, my lord.
Where are the respondents' counsel?
So the health department, but
Names have not been shown. This is regarding payment of some honorarium, is it?
my lord, the parity, my lord, within the my lord, contractual employees, my lord. We say, my lord,
They have filed affidavit.
they filed an affidavit, my lord. Deborah's name is shown, man.
So we'll have it on Tuesday then.
My
Tuesday. Mr. M. Datta, learned counsel for the petitioner, none has appeared for the respondents, although the name of the learned counsel is shown in the cause list. For ends of justice and to give one opportunity to the respondents to put in representation, office release this case again on Tuesday.
My lord.
For hearing.